Well, welcome everybody to Real Wealth's weekly webinar, although it's more of a daily webinar these days. Today, we're going to be talking about estate planning in a crisis. Can be a little dry of a subject and a little bit of a downer subject, but our presenter's not going to make it that way. My name is Ben Smith. I'm the Director of Investor Relations for Real Wealth. So glad you could join us. Normally, we do these every week on Thursday, but as most of you know, we're doing them every day. Because of the current situation in the country, just talking to various property managers. Obviously, we're talking to Michael today on estate planning and just letting everybody know that it's a changing, fluid situation, what's happening on the ground and what people are doing and how various markets are reacting from a real estate and property management standpoint. And we will continue to do that for the foreseeable future. We're filling up next week as we speak. And so we hope you can keep coming back. And these are all archived on our site, which sometimes I forget to point out. So if you can't drop what you're doing in the middle of your day, wherever you may be, you can log in and watch them after the fact. But today it's all going to be about estate planning and what to look for, what to avoid, what you need to deal with right away, and what you can wait on. So Michael, if you could advance for me, and I'll read our little disclaimer, introduce you, and we'll go from there. So the strategies mentioned today may not be appropriate for everybody. Other options not mentioned may be more suitable for your specific circumstances. Consult your personal accountant, tax advisor, and/or attorney to discuss your specific situation. Past performance is no guarantee of future results. Real estate purchases are subject to investment risks, including the possible loss of amounts invested. And while every effort is made to maintain an accurate and current information, the possibility of errors and/or updates always exists. So Michael Bowman is with Anderson Advisors, and many of you know that Anderson is one of our preferred asset protection groups. They're listed on our website. We refer people to them, among others. And what I think is unique about Anderson is they also do taxes. It's not just a bunch of suits running around. They're doing taxes. Whether they're wearing suits or not, who knows? But so it's kind of nice to have one-stop shop. You can do both. And obviously the third leg of the stool is not only asset protection, tax planning, but trusts, living trusts and all of that. So Michael, welcome.
Hey, thank you so much. You know, when Real Wealth reached out to us, I was really impressed, and it shows a lot about Real Wealth, taking it and looking at what investors need, and especially during these times, estate planning is so paramount. Unfortunately, a lot of people put it on what I call someday island. Someday they're going to get to it, and then all of a sudden we have a crisis like this, and brings it to the forefront. One of the things in creating this presentation, I didn't want a lot of doom and gloom. I just want to educate and kind of demystify what estate planning is, because as I'm going to show you, there's a lot of objections to it when you start thinking about it. And it's because of the inaccuracy of information out there. So I'm really excited to kind of just educate you guys and be there for you guys and kind of calm some of those fears out there.
Absolutely. And we will be taking questions as we go or at the end. So if you're watching this live, just go ahead and type a question in. Can't promise we'll get to them. A lot of times we get overwhelmed, way too many questions. But just type them into the question box there under the GoToWebinar control panel. And we will take them if we can, and if we can't right away, we'll take them at the end, or we'll try. So take it away, Michael.
All right. Well, I came up with some of the questions that they're being asked to us. Our estate planning division is of course, the uptick in the questions that we're getting and the number of people who are calling in about an estate plan. I took some of those questions and kind of boiled them down and then created a presentation around them. The first one is, hey, we got this coronavirus going around, and how do we go ahead and build a plan that's going to preserve our assets? One of the things that Real Wealth puts out there is how to build your wealth. The real estate investors out there, business owners, they're so concentrated on building up their wealth that they sometimes forget that they are going to pass. And how do you preserve all that hard work and sacrifice? I'm a real estate investor. Everyone in Anderson's a real estate investor. And one of the things that we need to do is be able to pass it on in a way that we can, in a way that doesn't hurt our heirs and preserves our estate. And so I put a lot of a thought and process into it. The other thing that we're seeing, and unfortunately Anderson has seen a lot of it lately, is the simple fact that people are going to the hospital, but they don't have their healthcare directives in place. And with mixed marriages, you got second marriages, you got common law, you got people who cohabitation, and some of those rights don't translate over to those individuals. And so what documents do we need so that if you do become incapacitated, there's someone there for you and are able to make those healthcare decisions for you? And then something that has been kind of a guiding light for me and what I want to get across to people is how do you what do you need? A lot of people say, what about just a will? And attorneys are happy to prepare wills for you, and I'll tell you why they are. But what kind of documents do you need? And I call it more of an estate plan as opposed to a living trust or just simply a will today. So in moving forward, why do so many people wait until it's too late? Number one, I think there's plenty of time. You guys are gonna be surprised, but I was like the doctor who smoked, where I think there's plenty of time. I for the longest time, even though I had created estate plans, I was an attorney. I thought, I'll put this on someday island, like I call it, and thinking, there's plenty of time. I don't have to get to it right now. There's a lot of questions to it, uncertainty. Again, it was uncomfortable for me. I didn't want to even realize that I might die one day. And I think that people are in that same situation. They don't want to have that realization. And so a very uncomfortable topic. And then what lawyers do typically is they make everything really complicated. We're great at doing that. And so once you start getting into it, you read a lot of internet articles out there, you get confused and delay sets in, and it's intimidating. And then the myth out there is that the attorney costs, drafting up a trust. Trusts are notorious, with the reputation of being very expensive. That used to be the case, but what we've seen with computers, word processing, and the ability to use computers to kind of accelerate the process, the costs have come down. So I don't want anyone to rely on the 5 reasons why people wait. You need to get these documents in place. One of the greatest things I see when someone does an estate plan is the peace of mind that comes around. After you get it done, it's done. And it literally is done. Once you have it in place, there's not a lot of maintenance to it. You should review it every once in a while. And I'm going to talk about what you need to review if you already have an estate plan, because some people, they get letters from attorneys saying, hey, you need to come in and let's review your estate plan. Well, a lot of these things you can do on your own. So let's just get down to the basics and what is an estate. Basically, your home, your car, sort of collections. Each one of these need to be planned for. Oddly enough, when people start looking at their estate, they think it's the real estate, they think it's the money that caused the problems, when in effect, basically what the actual cause of most of the family fights that I've seen in the past are the collections, like the stamp collections or the coin collections. And then also the family heirlooms. I've even had in my own personal life, in my own family, extended family, I've seen family relationships destroyed over those two things, collections and family heirlooms. And it's really unfortunate. It does hurt my heart when I see it happening. With everyone who's a real estate investor, you're not an investor, you're actually a business owner. And so that's part of your estate. And we really need to design it so that your business gets taken care of. The last thing, and again, I've got so much respect for real estate investors and business owners because they built something up, and we really need to protect that. And the estate plan is something that's going to do it. Now, here's the deal. If you don't have anything in place, you actually do have a plan. It's the government plan. It's called dying intestate. And the problem with it is, number one, it's very expensive to go through probate, but your actual private matters become public. And what I don't like about that is there's a lot of predators out there that basically will come in and say, hey, you know what? Let's look at the probate files, see what the individual owned, and then go after those assets. We've seen predators go after the family members of a deceased person because they know there's assets there. And one of the worst ones I saw was an individual going after widows and finding out that the individual died and there was a big estate, and magically fell in love with that person, and then really took advantage of the individual. And that's all because of it was public information. Within a probate, basically it's designed for a court to come in and decide who receives the assets, pay off creditors. And so again, since it's a court proceeding, it's public record. One of the things that also happens is the court system is actually notoriously slow. And so the family will have to wait months before receiving anything. We've all heard that once someone dies, their assets become frozen in order to pay off creditors. And so it causes a lot of inconvenience for individuals when either a sibling, a parent, a family member dies, and they need to access that money for funeral costs and just taking care of and tidying up and wrapping up the affairs of the decedents, what we call them. The average is about 18 months. Now this stat looks, 18 months. It's going to be shorter for a smaller estate. However, I've seen a lot that have taken over 18 months just because of how slow the court system is. The other issue, and this is really important for you and real estate investors, a lot of people think that if you die in California, that's where you're going to be doing the probate. However, probates go to where the assets are located. And, I always say as a real estate investor, I go where the deals are. So just because I live in a certain state doesn't mean I'm doing all my deals there. Well, if you own real estate in multiple states, not only do you have to do one probate, but you actually have to go and do probate in different states. Wherever those assets are located, that's where you'll have to open up a probate. Absolutely tedious. You think one attorney is expensive, try to get 2 or 3 from the different states to run through the probate, and they're all talking, and during that time, they're all billing. And so we want to make sure that we cut out the thousands of dollars that go along with it. I always say a living trust, because we don't have to go through probate with the living trust. A living trust pays for itself in multiples. So let's look at the risks ahead. One of the things that I love to do is dispel the myths out there. And the way we look at it is, if we look at the different ways that if we die and we hold our assets, what can happen. And so I put together a flow chart for you guys. With dying intestate, just having joint tenancy with an asset or having a will, you will not be able to control your guardianship of your minor kids. Guys, I'm going to talk about the importance of putting in a guardianship now as opposed to having a court do it. The different ways that we need to avoid probate, joint tenancy is one of them. However, you have a chance of losing your assets with the other co-joint tenant. The other assets that, bypassing probate, looking at controlling distributions after you die, we have to really be careful of that, because some of the ways that we used to plan are no longer relevant to the way we plan now. And so we want to make sure that we don't set ourselves up for, the methods of distribution go against our actual wishes. And then one of the things we really have to be careful now with a lot of second marriages and blended families, we have to make sure that we don't disinherit our children. And this is a big shock to a lot of my clients, is when they come in and they have a dated plan, or they don't have a plan at all, or a simple will, they don't realize that actually they can disinherit children. How this happens is, let's say that right now I'm married, my wife's Ellen, we have a child named Michael. Let's say I pass and I have a simple will, or I die intestate. Well, the problem is all of the assets that my wife and I have created and put together over the years will go to my wife. Now, I'd like to think that my wife will never remarry, but she's very attractive and one of the sweetest people I know. She's going to get remarried, and the problem is if all the assets go under her name and then she gets remarried, then they become marital property. And then if she passes, well, she will, her future ex or future husband he can actually change of where all the money goes. So all that work that Ellen and I have put together to create an estate, to create a lot of rental properties and own a lot of rental properties, they could actually go to her spouse, and then if she passes, he can control the distribution. Now we have a son and we have another daughter on the way, but the thing is he could actually disinherit our children. So that's something we need to be really careful of. And so, the problems with some of the older ways we planned, they sounded good, but as it played out over the years, we've seen some big detriments to it. Joint tenancy, this was really popular in the past. Basically, you own an asset. It's sometimes abbreviated on title as JTWROS. It's joint tenancy with right of survivorship. And how this works is, let's say that a guy named John and I own an asset together. The theory behind it is if so let's kill John off first. Let's not kill me off first. But if John dies first, I get all the assets and I control it. Well, then I disinherit any of his family members. The reason why people used it was it did avoid probate. Now, the issue is while you're holding the asset in joint tenancy with right of survivorship, the liabilities of John and the liabilities of myself, they go towards the asset. Now, if John gets in a car accident and loses, the case and gets a judgment against him, because John has a right to the whole, then that actual asset could go over to the judgment creditor. And so these are old ways we've used to plan. These are not the ways we plan anymore. And so we want to look at some of these more in depth. Wills are very popular. They've been popular for centuries now. Reason why is basically they just go ahead and they take the estate and they designate the beneficiaries. Who's going to get what, and who's going to carry out the plan. And they're somewhat cheap. I think Legal Doom can go ahead and they'll draft a will for probably $99. And in fact, in Las Vegas, where I used to live, basically I saw a billboard and it said wills $99. Now, I had to scratch my head because I don't know any attorney who's going to draft anything for $99. You can't do it and be profitable. And so what, in looking and analyzing it and trying to figure out why an attorney would actually draft a will for $99, the only reason they would do that is because it's a lost leader. When they draft a will, what they're going to do is put on the footer, they're going to put their contact information. And so the family members of the person who died are going to get that will, look at it, the attorney's name is John Scumbag, whatever it is, and say, wow, John Scumbag must have really known father or mother. Let's go ahead and have them do the probate. And then the probate is we're going to find out that's where the real money is, because it's very easy work and you can build the estate. In California, it's 8% of the estate can go to the attorney. And the reason why is because it's probate. The attorneys want that probate because of the length of time. And so basically, looking at the probate process, a will does have to go to probate because it is the decedent's estate, and the court needs to look at it. Very expensive. Like I said, 18 to 24 months is what I'm seeing in the industry. Anderson belongs to a think tank of all the top estate planning attorneys out there, and we bounce ideas off each other, and basically what I'm seeing is over 18 months. And during that time, the attorney's billing the estate for it. Again, like I said, it's public record. The other issue, and there's things when you're a business person like myself that you look at and you say, all right, so with the business person, you want to make sure that everything's in place and you want to make it efficient. Well, the problem with having a will, maybe that's short, and most wills are, is the fact that it's very easy to contest. We all see this happening, and I know that you have seen this in your personal lives. Grieving and greed, they go together. And so let's say that a family member isn't happy with what they received. What they generally do is bring a will contest. And so then that ties it up in the court system even longer. The unfortunate thing is you get two types of individuals. Some of the individuals out there will just say, hey, I don't want to fight over this, and just go ahead and give up the assets and give it to the person who's the squeaky wheel. Unfortunately, and a lot of people don't know this, is probate expenses are voluntary. Because if we're going to find out if we use a living trust, which I advocate for everybody, a living trust doesn't go through probate. And so we'll get into that right now. Here are some stats on how much probates cost. Like I said, California, 8% of the estate will go to the attorney. Like, it's very, very expensive. And then the loss of privacy. So let's look at the living trust. This is what I want to get into. I want to get into you guys understanding why we advocate for living trusts. Anderson will not create a will unless it's for one of our clients that postponed it and they're on their deathbed, and it's the fastest thing that we can do. I hate doing it. I've said no a lot of times. But a living trust, how it works, think of it like a suitcase. And what you're going to do with the suitcase, you're going to take all of your assets and transfer your assets into the living trust. Now, with that is basically you've taken all the ownership, put in the trust. You no longer own the assets, but as we're going to find out, you can control them and benefit from them. So estate planning area of law is one of the places where you can have your cake and eat it too. The best thing about the living trust is, again, you retain control and the benefit of it. Now, the other misnomer that I find out is that people think, oh my gosh, if I go ahead and transfer all my assets into the trust, I'm stuck. Well, no, that's an irrevocable trust, and I'll explain the difference a little bit later, but you can change and revoke this trust at any time you want. Now, in looking at that, life changes. And so over time, situations change. Well, if that's the case, you can go ahead and do what we call a restatement or amendment to the trust and address the provisions in the trust that change over time. It's absolutely fantastic. Again, it's one of the few areas in law that you can actually kind of mold with as life goes on. The neat thing about it is because you don't own the assets anymore, once you pass, then the assets in the trust, they directly go to the beneficiaries that you've stated without going through probate. Now let's just kind of break down some myths, because I'm gonna be honest with you. When I got into estate planning, when I had my first trust and estates course in law school, I had one of those mental blocks. I always thought that a trust was for the Rockefellers, the Kennedys, and my last name's Bowman. So I thought they were for the other guys, right? It wasn't until I got to the chapter where it broke down the different types of trusts that I started to see, you know what? These aren't too difficult. As long as you understand there's two types of trusts: revocable trusts, which obviously can be changed. These are our living trusts. And then what we've got is irrevocable trusts. These are spendthrift trusts, asset protection trusts. Basically, what we do is we put the assets in, and we want to kind of distance ourselves from the assets so it gains asset protection, and so that it doesn't disrupt any of the benefits that maybe some special needs individuals are getting from governmental assistance. And the next thing I had to do to actually understand trusts was really break down the players of the trust. The players of the trust, and these words, sometimes we kind of get intimidated by the words here, but the grantors, they grant the assets to the trust. That's a no-brainer. It says it right in the actual word, the definition's right there. And then the trustee, they actually control the trust and the assets of the trust according to the rules of the trust that you went ahead and put into place. Neat thing about this is that the trustee controls it according to your wishes. They don't have free reign. Your rules are in that trust. And so you've gone ahead and you've designed it according to how you want it to be distributed out and the control. And it's really neat because you actually have control beyond the grave. The last party of the trust is the beneficiary. Again, the definitions in the word. Beneficiary, they benefit from the trust according to the rules of the trust. I always make the joke that if attorneys charge for everything, but I'll be your beneficiary of any trust you set up, and I'll do that for free. And I'm just kidding. I can't be your beneficiary. All right, so we avoid probate. We talked about that. Now, the neat thing about this, and you can see what some of the celebrities have passed. Unfortunately, some celebrities, I can't figure out why, but some celebrities used a will, and now they're in probate, and everyone can see how much money they're leaving to certain individuals. With a trust, because it's not public record, you maintain privacy, and in return, that actually is going to keep those family relationships intact. What we also want to do is a living trust, as it says, it's a living trust. So even when you're alive, if you become incapacitated, the neat thing about that is you'll designate somebody to control those trust assets why you are incapacitated. And then once you regain capacity, then you can go ahead and take over. The neat thing also about a trust is with blended families that we can go ahead and take care of our children from previous marriages, as well as keep and keep our current spouse and make sure they're planned for and taken care of. The other neat thing is I'm going to show you a couple ways we can design the trust in the fact that we can control the distributions. We have to love our children the same. Well, most of us love our children the same, but at times we're going to have to plan for individuals, and we can love them all the same, but we're going to have to actually take into account the type of individuals. You know, sometimes we have children who like to spend money like crazy. Then you have children who, you know, will save every single nickel. And so there's ways we can control it and protect. What I always like to say is protect the beneficiaries from themselves. In controlling the distributions, we've got a couple different options. Now, here's the deal. We can go ahead and have on your passing that all your children, they get the assets right away. One of the things we want to do is make sure that the children do not convert those assets into marital properties. The last thing I think you want to have happen is that you pass away, your children get the assets, and then they have to split it with a future ex-spouse. There's ways that we can control it so that we make sure that it doesn't become part of a divorce proceeding. Then what we can do is we can go ahead and plan for distributions, especially with young children. We can make distributions. I'm going to show you a couple different distribution schedules. I'm going to actually share with you the way I've got my trust set up for my 3-year-old Michael and his soon-to-be born sister, in the fact that we can make sure that kids don't get the assets directly at 18. Now, I know myself, I always consider myself pretty responsible, but if I got all my parents' assets at the age of 18 and I was in college, I'd be the king of my fraternity. I guarantee it. Until those assets ran out. You know, we want to make sure we help our children and we teach them financial stewardship, but we also want to kind of protect them from themselves. And so we can actually outline ways that we can keep the money, make sure that they can achieve their own goals, and then keep from divorce and creditors, lifetime. One of the things we can do is create what we call a dynasty trust. With a dynasty trust, is we can have it go over multiple generations. I always caution people when we talk about this in the fact that you don't want to control it for too long. You know, the last thing we want to do is put rules in when we don't understand the future generations and the way that they are. And then, unfortunately, in today's environment, we have a situation where you know there's a big substance use problem out there, and not to get kind of be a downer, but we really need to make sure that we don't leave our estate to individuals that have substance abuse problems. One of the stories I like to share with individuals when we're talking about trusts is you are the last person to understand that they're going to have a substance abuse problem. I almost recommend to every single client that they do put a substance abuse provision in there. And what that does is that before the distribution goes out, a drug test is implemented. If they pass, they get the distribution. If not, and this is really neat, the trust can go ahead and get them into a rehab. And then when they get clean, they can go ahead and get their distribution. Now, you know, I've had, you know, extensive conversations with clients. One of the worst ones was we had a lady come in and she wanted to create a trust, and her son had been in rehab 2 different times. We talked about putting a substance abuse provision in there. And she said, no, I don't want to go ahead and offend my child. And so at times we get a wrong answer or an answer we would prefer not to go forward with. We wait a little bit and then come back and circle around. We asked again and again, and she would not put the substance abuse provision in there. And what happened was when she passed, the money went to her son. Her son was found, you know, a few weeks later in the bathroom with a needle stuck in his arm by his 9-year-old sister. That was heartbreaking because, you know, she didn't offend her son, but I really believe she killed her son. It was totally, we could have avoided that whole circumstance. And so, you know, the way I look at it is if your children want a distribution, they're very fine to go ahead and go get a drug test, get their distribution. If they're not abusing drugs, no big deal. They get their distribution. If not, then they can get the help that they need. And then the last thing we really want to pay attention to is if you do have special needs children, we want to make sure that we're not excluding any of the governmental benefits that they're going to be receiving, so we can draft in a way that's going to preserve those governmental benefits. So that's a little bit on control. Now, one thing that I promised you, the way, and this is
Hey,
one
Michael,
of the most popular
real quick,
schedules that I've seen.
Michael,
yes.
Sorry, I've got a bunch of questions here. I don't know. I'm kind of struggling with the idea. Should I just read a couple of them off? Because I don't want to steal your thunder. Okay, I don't want to get you off track either. Okay.
No,
so,
you know what? Even if you get me off track, I'll get back there.
Okay, no problem. I mean, some of them are appropriate to what you've been talking about. And if you're like 2 slides away from getting to this subject, just say, oh, we're about to get to that.
No, let's strike when the iron's hot.
Okay, so a couple of questions are just, okay, obviously most of our audience are real estate investors, as you mentioned at the beginning, but a couple of questions on once a trust is created, how easy or difficult is it, or how do I add properties to a trust? Do we go through a title change, or what is the process?
Okay, excellent question. Because again, these are the things that get kind of intimidating. There's a lot of articles out there. Everybody should be owning their properties in, a limited liability company. The way it's taxed, we're going to have to figure out. One of the things that I'm going to recommend you guys is get a one-on-one with one of our senior strategists. The way that we do is we title them in the name of the LLC. The way that we prefer is wherever that property is located, that LLC is going to be in that state, or we can use a variance of that with maybe a Wyoming. But then we want to have that property, the ownership of that property in the LLC. That LLC should come down to what we call a holding LLC. It should be out of Nevada or Wyoming. And then what we do is we change the ownership of that holding LLC into the name of the living trust. Now, the greatest thing about this is we do that through the control of the actual ledger and their certificates of ownership. So basically, you might have an LLC right now that you're the owner of it. On the back side of that ownership certificate is what we call a transferability section. You transfer your ownership into the name of the living trust, and that's how easy it is. The greatest thing about this is a lot of people think it's so much maintenance. Well, let's say we sell that property. Well, all we do is we dissolve that LLC, and then the certificate of ownership goes away. We don't have to keep updating the living trust because everything that's titled in the name of the living trust owns. So absolutely easy to change ownership. And we do it through the certificates of the limited liability company.
So in other words, if somebody has this all set up, they go out year 5, whatever, and they buy a new property in Ohio, for example. Yep. They're getting financing on it and get a Fannie Freddie loan. They'll probably have to put the financing in their own name. So they buy the property in their own name, get the financing in their own name. Then they go out and create an LLC based in Ohio. They convert that ownership of the property over to that LLC, but then that LLC is listing the living trust as a manager of that LLC.
I'm going to bring you out to start teaching some of my courses. This is fantastic. Absolutely. That's exactly how it works. Okay. And so the ownership of that LLC, there's going to be a ledger and a certificate. If you've created your own LLCs, they're not going to have that, but you really need to make sure those binders are in place with an actual ledger of ownership and actually the actual certificate of ownership too. And so yeah, that certificate of ownership that controls. Now there's some variances to it. In some states, we're going to want to use what we call a land trust, and don't be intimidated by that. Again, that's a revocable trust that we might want to hold the property in the name of the land trust to bypass some of the transfer taxes. Maybe even a due on sale provision in some states. But again, if you get a consultation, we'll run through that with you individually one-on-one. But you're exactly right. The ownership of that LLC is owned by the living trust. And so if we sell the property or we move it out there, then that asset is no longer by the trust, and the living trust no longer controls it. Excellent question. Let's take another one.
Okay, here's one other. Individual LLCs are expensive in California. I think it's like franchise tax board is like $800 or $900 per LLC.
$800. You bet.
$800. Okay. why not use a Delaware Statutory Trust series, DST? Maybe you don't want to get into that. I don't know.
Yeah, um, I'm kind of an advocate of doing things tried and proven. Okay. I know that $800 is a sticking point to a lot of people. I say it's a cost of doing business. It's an expense. It's going to be a write-off. I would much rather go in front of a court and have things the way that they understand it, and especially in California. California does not want to look at other laws, and we've seen it where if California doesn't understand it, they don't like it, then they will disregard it. And so our preferable way is, yeah, go ahead and create a California LLC. Now, there are workarounds, and again, we got to look at it one-on-one, not one size. One size does not fit all here. But I would really look at it if it makes you feel better. Amateurize it over. Take the $800 and amateurize it over 12 months. It makes you feel a little bit better. But again, we've got to look at it from the bigger picture. It's very easy to go ahead and write an article as an attorney or a salesperson that you use all these new and creative methods that haven't been proven, and it sounds sexy, but here's the reality of when you're talking about asset protection and estate planning. We want to make it so we only go with methods that are tried and proven. We don't go out. Now, I'm not saying that it's not going to work, but there's been some questionable cases with Delaware Statutory Trust that we're just not really comfortable with them right now.
Okay.
A lot of attorneys want to get their names in the appellate courts or Supreme Courts. It's kind of a badge of honor for some attorneys. I always view it as really a disservice to a client when you start getting into these creative schemes, is what I call them, because what you're going to do is you're going to cost your client a lot of money going through the court system. In California, again, they're a sovereign nation almost, where they want to take their laws and apply it. And if they don't like something, they'll disregard it. And that's something that I do not want my clients. I don't want my clients to be a test case for.
Right.
I'm a little bit passionate on this because if you know my background, I put myself through undergrad and law school, and I joke around that I can make top problem in 50 different ways. And in order to build my portfolio and my investments, I had to do a lot of sacrificing. And so my clients are the exact same way as I am. And I don't want to have something where we saved a few bucks cost them their entire estate. And so, yeah, there's times where we can use them. We want to be able to analyze it. It's going to be a case by case basis. But I really counsel people to get over that $800.
Yeah.
Think of it as like insurance. And you just hit kind of one of those my passion areas. Think of it as insurance, amortize it over the 12 months. And not saying that we won't use some of those different methods, but we really want to analyze and make sure it's best for the client.
Well, there are some ways. There are some ways around it, and I think maybe just don't. If you have 10 California properties, don't have each property in a separate LLC, because then that's $8,000 a year. I mean, you can
combine it. Now, again, we want to kind of do a balancing test. This is a great point here. Do a balancing test. Say, okay, so let's look at maybe combining some properties, but how much am I willing to put into one pocket? And what's your risk tolerance? Again, the way that we set it up with unlimited LLCs, for one price, it gets really cost effective. And, cost is always an issue, but we don't want to make it where we're, subjecting ourselves to too much risk. Using some of the new methods out there that haven't been proven, I've seen really backfire. I've seen clients where the court didn't understand, especially in California. California, again, I love California. I was born and raised in Walnut Creek, California. And the deal about that is that if they don't understand it, what they're going to do is disregard the entire structure. But that means every asset goes back into your name. And then the judgment creditor has free reign over.
Right. Okay. So we got to kind of keep moving here. So I'm going to ask you this one other question and then get you right back on track. And I think I know the answer, but I'll let you. I mean, can a living trust protect our assets from creditors?
Oh my gosh, I love your guys' questions. You're almost taking everything that's the rumors out there and things I want to protect you guys against. A living trust is what we call a revocable trust. The courts looks at it like this: if you put an asset into a revocable trust, there are not asset protection features to that, because if you can put an asset into it and take it back out, your judgment creditors can too. So no, there is no asset protection inside a living trust. I'm so glad you brought that up.
Which is why you put the properties in an LLC and then title the LLC as have the living trust as a manager of the LLC. So you're getting the asset protection with the LLC, but when you get hit by a speeding cement truck, the property then goes to the living trust, avoiding probate.
Absolutely.
Okay.
And the way that we look at it, you did a great job in explaining the way that we look at our investors, our clients. We look at them from an asset protection standpoint because we got to preserve our assets because of all the hard work and sacrifice. It's also our retirement and it's also our legacy to pass on to our children. We have to be tax wise when we do this too. So we blend all this stuff together and it's overlapping, but we have to hit the areas in those major points. You know, we got to protect it and then we got to minimize the taxes. We also have to set ourselves up from a tax planning standpoint. I've heard too many asset protection attorneys protect it from a tax-wise standpoint and a liability standpoint, but then they forget that our clients are going to need financing and they set up in a way that they can't get financing. So we have to do some business planning. And then the last part that all fits together is that estate plan. We got to be able to pass it on to our heirs in the way that we choose. One of the misnomers is I just need a living trust. That's what people say. That's why Anderson calls it an estate plan as opposed to just a living trust. In fact, here's some of the documents that you're going to need. And again, a lot of attorneys they bill you per document. It's all part of Anderson's estate plan. We don't just nickel and dime you. You have to have these documents for a proper estate plan. Let's go through some of them. Here's that distribution that I was talking about that actually I have for my son right now. And with a living trust, we can individually plan for our beneficiaries. Right now, I've got it set up. At the age of 25, my son gets 25% of his inheritance. Now, the great thing about this is, as the picture shows, you can play puppet with your kids. If I feel like at 25, he's not going to be financially responsible, I can change this distribution. The reason why I chose 25 is at 25, I hope to have taught him financial stewardship. And what I mean by that is, you know, if he gets that 25% distribution, then guess what? He hopefully invests it, pays off some debt. And let's say that he doesn't. Let's say he wastes the entire 25%. He gets buyer's remorse. Well, he's not getting another distribution until the age of 30. Now, the other thing is one thing that's important to me is I want my son to realize his own goals. And what I've seen with 18-year-olds is that if they do get a inheritance, they feel like it's all the money in the world, and they cease to go after their own goals, and they rely. You've all heard of the trust fund kids. One of the individuals that I had the pleasure of knowing was very intelligent. He was one of those people who just got it, and he was in law school. He was one of the top of the class. We used to have a competition all the time. Well, he would have been a great attorney, great heart. He got an inheritance while we were in law school, never took the bar exam, blew through all that money. Years later, had to go back and try to take the bar exam. The older you get, the harder the bar exam becomes because you're outside of a textbook. And you know, he never went back and became an attorney. His parents changed him, changed his life. And so I don't want my kid to get all the money all at once. Age 30, let's go ahead and give him another distribution. Age 35. And again, we can change this at any time. The other thing reason why I like this is it's almost like putting a prenuptial agreement inside your trust, where if the individual, your child gets a divorce, well, whatever's been distributed out, there's a potential that they might have to split it with a future ex-spouse. Well, any money that's still in the trust is not subject to the claims of a future ex-spouse. And so what we've done is put a prenuptial agreement in there. You know, we do have to, you know, counsel our kids and say, hey, you know what, do not commingle the assets. And every marriage is different, every child is different, but we can plan individually for it. We're able to change this up until we die. And again, protect the beneficiaries from themselves is something that's very important. One of my favorite document is from a legal standpoint. This is probably the flimsiest. It doesn't have much prowess to it. It's basically an outline of who gets what and when they get it. Upon your passing, you'll have what we call a schedule of gifts. And what this does is it minimalizes family disputes. I've seen too many people fight over the knickknacks. The worst thing I ever saw was was two sisters fighting over what we call, or what they call, I don't even know what these things were. I didn't know it at the time, humble figurines. Well, I've seen family relationships destroyed over the knickknacks in the family. This one particular, these sisters were fighting over who gets more of the humble figurines. One of the sisters' arguments was because she had one more blood grandchild, she should get one more. I had no idea what these were until I went into a German restaurant and I looked at the figurine and I said, what in the world would the actual 8-year-old grandson need with this humble figurine? To get put in perspective, my dad and I, we used to collect stamps when I was a child. And it was time where my father and I spent. Now, if I look at it, I have a brother who's 6'10" and weighs about 330. Big guy, right? My dad does not separate out who gets what. My brother is going to want that stamp collection, and he's bigger than I am. Now, I might be a little quicker, but we'll fight over it. And the reason why I want it is because of the sentimental value. It was a time I spent with my father. I got some of my business acumen from him because we would do negotiations over the price of the stamps that I'd buy from him. We'd call Stamp Sale Sunday, which is stamp shows, things like that. It was times I spent with my father. Now, my little brother might want it from a monetary reason. And so there comes a conflict. With the schedule of gifts, you list the asset down and who gets it, and you sign it, your initial and date it. With my extended family, a family member passed. By the time I was able to go to the residence, the place looked like it had been burglarized. I really didn't get anything that had sentimental value. Grieving and greed came into it, and it seemed like my extended family came in and grabbed as many assets as they could. Not because it really meant anything to them, but they were trying to fill a void. Again, grieving and greed. One of the most important documents in the estate plan. Core of a will. I know I kind of bagged on wills earlier, but what we do is, because people get busy and don't always title everything in living trust, we actually put a will inside the estate plan. And basically what this does is it catches into the assets that were failed to be put in the trust, and it puts them into the trust and then distributes according to the rules of the trust. One of the most important documents that is in that estate plan. It basically saves yourself from yourself. We get busy, we buy assets, we forget to title them, and so this goes ahead and does it for us, and then it shortens the length of time. Make sure, guys, I cannot stress this enough. If you have children under the age of 18, you need to make sure you have guardianship provisions put in place. Sometimes you have a situation where people fight over who wants to take care of the kids, and you get both sides of the family saying we're better. One of the worst situations I've seen is, the kids would go over to one side of the family, and that side of the family, what they would do is they would badmouth the other side of the family. And then the kids would go to the other side of the family. That side of the family badmouth the other side of the family. It was at a time when the family should be coming together to support the children. They didn't. They pulled them apart and caused conflict. You guys choose who you want to take care of your kids. And I want you guys to choose. I don't want the state to decide. Unfortunately, one of the worst situations I've seen is when the state got involved and placed the children in with an aunt, and their logic was that the aunt lived in the same school district, there'd be less disruption to the lives of the children. The state failed to know that there was a substance abuse problem, a severe meth problem. And the kids, there was 2 girls, 7 and 9. And those 2 kids, they saw things they should never have seen. They needed counseling for some time after that. So we want to make sure that we choose who takes care of our kids. One of the most important things we need to put into place, especially with what's going on with the COVID, is that we want to go ahead and make sure that we have a power of attorneys in place. There's a couple different kinds. We got a medical care power of attorney and a financial power of attorney. Financial power of attorney basically designates a person to take care of your finances. So if you're incapacitated, they can pay your bills so that when you come back and that you're not, you haven't lost your house, your bills have been paid, and the finances have been taken care of. The other thing that we need to make sure we have in place is our health care power of attorney. Again, sometimes people have been living with people for a long time. The hospitals will not allow you to make decisions because you don't have the same name, you don't are married. It doesn't default from any state. So what we need to do is put someone in charge of your healthcare decisions if you're incapacitated. We're seeing, and I'm hearing, and I belong to a lot of journals here, we're hearing a lot of people trying to go make medical care decisions and being rejected because of, there's not a marriage in place. They don't have a proper healthcare power of attorney. Want to make sure those comply with HIPAA law. And then what you need to also do, I need you guys to go ahead and make sure you have a living will. A living will basically designates your level of care. Do you want to be pain free? Do you want artificial hydration, nourishment? Works in conjunction with your healthcare power of attorney. Your healthcare power of attorney can be different from your trustee or your executor or executrix. Sometimes you want to look at who's going to be able to make those tough decisions for you. I always joke around that I don't want my older brother to be my healthcare power of attorney because he wants the money and he's going to pull the plug if I get a headache. So no, I'm just kidding, Todd, out there. But there's different types. You might want to have an accountant do your financial power of attorney, and maybe a nurse or a different family member become or a family friend do your medical care power of attorney. The final thing I really wanted to cover, guys, is during this time, it's really tough, and you really need to go ahead and outline your memorial instructions. Do you want a funeral? Do you want to be cremated, buried, things like that? Take all those decisions off of your family, and it will decrease fights, and it's just a little bit easier. I've had some funny last memorial instructions. One of my close clients, they wanted their ashes distributed in the Pacific Ocean at the back of a boat. And they were really adamant that it had to be by the back of a boat because they were afraid their family was going to go get a hotel room in San Diego, dump them in the toilet, and hit flush. Kind of a funny thing when you run into this. You really have to be careful that you don't put too much stress on your family members. You need to designate out who you want to attend your funeral. Take care of all those decisions for your family. It just helps them out because it's already a stressful time. You really want to make sure that those are in place. The question comes is what happens if you already have a living trust? I know that you guys are going to be getting letters from attorneys. Do you need to go in there and have them review it? No, the answer is, maybe, if it's a, will for, or a trust from the 80s, but you can go ahead and do a preliminary inspection. What you need to do is go through, look at the beneficiary designations that you made. Look at your financial power of attorney, your healthcare power of attorney. Are these the people that you want to be making those decisions for you? The living will, are those still your wishes? Continually to update your schedule of gifts and your final instructions. For the most part, the way that Anderson drafts a trust, it is the way we feel is it's tough enough to get a person to do a trust in the first place. What we want to do is make sure that trust is going to last a lifetime, whether or not you go in and have it updated all the time. We want to make sure that it complies. And there are some provisions that are quite broad. An attorney came to us one time and said, why did you put an S corporation provision inside of the trust for this client? They don't even own an S corporation. Well, the reason why we did that is because what happens if the client goes ahead and acquires an S corporation? We want the trust to last you a lifetime. Again, we might have to do some updating through an amendment or restatement. It's very cheap and very quick. But for the most part, you can go through, and I would recommend you review your trust every maybe 3 to 5 years, depending on your life circumstances. If life circumstances change, it's another time to do it. But you guys really can do the review yourself. If it is a trust that's back from the 80s or early 90s, we want to take a look at it. But for the most part, you can do your own trust review. And so one of the things that we've come together with, and we wanted to make sure that we kind of met our clients halfway. Instead of $3,500, we are doing trust right now at $2,500. Partners got together, myself and Clint Coons and Toby Mathis. and said, what can we do these at to get more people to have a living trust? We're so sick of people, passing away without an estate plan. I've had some really great experiences. Unfortunately, when people die, that grieving goes on and frantic. One of the best experiences I had that really is a testament to a living trust is when one of my close clients, his name was Eddie, and what Eddie did was, Ed basically, he used to call me, and it seemed like every week, and ask me really simple questions, and then we talk about life. And then one day he let me know that he had pancreatic cancer. And then he thanked me for the conversations we had. Then all of a sudden I didn't get that call, and I got a call from his son. And his son's name was Michael also. And his son was very upset in the fact that, he thought everything was going to be frozen. And he said he felt like a failure because he didn't have money to bury his father. And the neat thing about this was I was able to calm him down, and because we went through the trust, and I told him, hey, nothing's going to be frozen. Everything is in the trust. There's money in the trust. Go ahead with the certificate of trust, which is in the trust. And the death certificate, you go down to the financial institutions. There's money there to take care of anything. The best part of it is you can actually not go through all the red tape, all the bureaucracy that the institutions want you to go through. But more importantly, you can grieve the death of your father and support your sisters. Everyone needs a trust. And so I hope I've kind of shed some light on the things we need to take care of right now. I hope that you guys take advantage of this deal. The other thing, and it kind of fits into it, we really need to make sure our assets follow the four-prong approach that Anderson does. And so with that, you're also going to get 2 tickets to our 3-day asset protection course. And then also I threw in 2 books because you guys are real estate investors. My partner, Clint Coons, wrote an excellent book on asset protection for real estate investors. What he did was he kind of dummied it down. He brought it into saying, hey, basically, let's take this and, how to do asset protection and kind of give an overview of it. And then since business is my passion, I wrote a book of how to start and run your business the right way, business compliance, and how to keep your business safe from lawsuits and audits. And so those are 2 of the bonuses. If you go ahead and you go to andersonadvisors.com/VetKey, you'll be able to sign up for that. I'd encourage everyone to take care of this situation now before it's too late, and get that peace of mind that comes along with it.
Okay, Michael, got a bunch of questions here. I'm sorry, I'm going to apologize in advance. We are going to run over, but I just, this will be archived on our site. You'll always be able to watch it again and again if you want. But I don't want to cut this off now because we've got a lot of questions here and they're pretty good. So let me ask you, were just a couple minutes ago, you said, hey, unless the trust was written in the early 90s or late 90s, you can pretty much review them yourself. Now, if you're like me, I actually do have a living trust, but it's like, it's thick. And the idea of reading through it, I'd almost rather pull my fingernails out. So what if someone's like, look, could you just look at my living trust and then we can make alterations if necessary? And plus it was done in another state. A lot of people that got a question here, done not even that long ago, maybe 5-7 years ago, but it was done in another state or whatever. Will you guys review those?
Yes, absolutely. Absolutely. Okay. For our clients, you sign up for a strategy session. Again, you move states. We might want to update the actual, what we call a status of the trust. Although with a trust, it's a contract, and so we're able to contract for the actual jurisdiction. We've drafted a lot of our trusts out of Nevada because we have a long, what we call a statute where we can go 365 years. If you've moved states, one of the things we definitely want to do is go ahead and update your medical care power of attorney and your financial power of attorney so they comply with state law.
Okay. All right, let's see. Got a couple questions here. Well, a lot of questions. So one, where was it? Come on. So this is back to when you were talking about wills. If a will is part of a living trust, it's not connected with probate?
Okay.
I don't quite understand that.
Yeah, no. Excellent question.
Okay.
it's part of the estate plan, right? So you have your living trust as a standalone document. Now, because like I said, people get so busy, sometimes they forget entitled assets in the name of the trust. And so what we've done is put a will in there. And what that's going to do is go through a short form probate to get any of those assets into the trust. It basically says, hey, take all these assets, title them in the name of the trust, and then distribute them according to the rules of the trust. I call it a catch-all.
Okay. All right. And this, since you've got the slide up that talks about the cost structure, got a question here that's, what is Anderson's fee to create a living trust, which you've addressed, $3,500 for limited time, $2,500, but does that fee include the cost to prepare, notarize, and record the quitclaim deed needed for each investment property? If quitclaim deeds do in fact cost extra, how much for the preparation, notarizing, and recording? And he mentions that, he realizes the costs are different based on counties. But
yeah, now there's two ways we can do it. We do a lot of deeds in particular states. Now, one of the things we don't recommend is quitclaim deeds.
Okay.
It can cause some problems with sales down the line, insurance, things like that. Warranty deeds, grant deeds are going to be something we're going to be using.
Okay.
A lot of your title companies can go ahead and do it. I see it ranging from 250, 300 per deed. But yeah, a lot of my clients, they have relationships with title companies and they get them done pretty cheap.
Okay, so it is extra then. In other words, you'll set up all that, but if somebody has 20 properties and they're all in their personal name, and you recommend setting up LLCs, moving the properties to those LLCs, and then marching down to the whatever county courthouse is and changing the property from Sally Sue's name to Sally Sue's newly created LLC domiciled in that state, there is an extra fee.
With this trust, what I included, because we started looking at it, and there's so many different situations out there. I really want each of you guys to go ahead and sign up for a strategy session when you get the trust. And then what we're going to do is we're going to take a look at all of your documents, your whole situation, and we're going to create a blueprint for you. It's your guiding light of your investing and how it's protected from a tax situation and an asset protection situation.
Okay. Here's another one. I heard that one should be careful of trusts because lenders do not allow them. Is this true? Missy, who's our property provider in Cincinnati, mentioned this in her webinars. Can he explain, please?
Okay, financial institutions are weird. I think everybody understands that. Back in about 2006, we started seeing where you didn't have to take them out in your own name. You could go ahead and refinance properties in LLCs. We saw it change when the downturn happened. Financial institutions got a little cagey. I'm seeing it where you can have your titles listed in the trust. You can have them listed in LLCs, and banks are going to go ahead and do refis or even financing. If not, then what you do is you go ahead and take the property in your own name, and then go ahead and after the financing's done, then you go ahead and deed it into the trust.
Right.
Oddly enough, I just ran a situation where they mandated it in an LLC. So, every financial institution is different. Your senior strategist is going to go ahead and be able to take care of that for you.
Okay.
Excellent questions. I love these questions.
Here's a good one from Lisa. How does having LLCs inside living trusts impact the cost of taxes, or what are the tax benefits of doing that?
Oh my gosh, another great question. One of the things that's important to us, we want to approach it from an asset protection and tax. And the problem was when you go to an attorney, they don't look at the tax side most of the time, and the accountant doesn't look at the asset protection side. And we want to make sure it all blends together. One of the way that we set up a lot of long-term, now we do short-term too in a different way using a corporation, but one of the things that we do is make sure that we don't leave any tax breaks on the table. So a lot of times we're going to set these up as in what we call disregarded LLCs. So all those tax benefits flows down to you and your own personal tax return. So we don't want to, we're not nullifying any of the taxes or any of the tax benefit of it. It's still going to flow down, and we're going to be able to capitalize on this.
And disregarded entity, meaning the entity.
This is interesting. Like, the state's going to see it. It's going to protect you, but from the IRS's standpoint, it's not even there.
Right.
You're basically telling the IRS, hey, look, don't look for any return here. The income or loss is going to flow down to this return.
To my 1040.
There's many ways we can set you up, but one of the things is our preservation of those expenses and those deductions.
Gotcha. All righty. Let's see. How do I do triage on these things here? Okay, here's one. When I went to get a HELOC, they wanted to know, and I assume they is the lender, they wanted to know that my home was not owned by an LLC in a trust. This was Wells Fargo. They said if so, they wouldn't be able to do it.
Yep, this is typical. What you do in that regard, you go ahead and deed the property in your own name, get the HELOC, and then if we might want to use a land trust. Again, this is why that one-on-one is so important. Is we might want to use a land trust to deed the property back from your name into a trust, and then have the beneficial interest in LLC, and the advisors can go over that. But yeah, it's not uncommon that lenders are a little cagey. They don't understand some of these things. So what we do is we just play their game and put it back in your name. And then once we get the financing done, then we go ahead and either deed it directly back into an LLC, or in California, we don't want the reassessment. And so what we were going to do is go ahead and deed it into a land trust,
right?
And then have the assignment of beneficial interest go to an LLC. Fantastic question. I know people are maybe a little confused on what I just said. Again, that's where that strategy session comes into play.
Yeah, I mean, Nick asks a question exactly. If I have let's see, I have a question in California. If you transfer the assets to the LLC, the tax assessor's office will reassess the property with the new property taxes. How can you avoid that? And I think you just land trust.
Yeah,
right?
Well, what are the exemptions to a revocable trust? And so we look at the code, and we say, okay, so we can go ahead and use it to our advantage. And it's important to get the steps right, but we'll walk you through all of this.
Okay, let's see here.
I love your group, by the way.
Great. We like to think pretty astute group. We love our people. All right, let's see. Okay, if you create a revocable living trust, can it be turned into an irrevocable living trust at a later date? Or would you ever want to do that?
It will on your passing, and that's a good thing, because once you pass, you don't want someone coming in and mucking the system up and changing all of your directives. It depends on the circumstances. Generally, you might have side-by-side trust, one revocable, one irrevocable, and it's going to depend on your certain situation.
Got it. Okay. Okay. If I have an LLC, is it okay to have the sole member of the LLC be the trust?
Yes, but we're going to have to we really want to pay attention to this. And I don't have time to get into the asset protection side of it with charging order. Just know that in California, the asset protection side has been weakened by the courts and by the state statutes. Now, we would most likely want to, if you have a rental property in an LLC, we want to bring that ownership down to a Nevada or a Wyoming holding LLC, because Wyoming and Nevada have kept the asset protection side of the LLCs. A problem happened about 8, 9, 10 years ago where all LLCs were created equal. A lot of the state statutes copied each other, and then California, Colorado, and Florida started weakening them. And so how we bolster it is by having that Nevada or Wyoming holding LLC, which kept the original intent and the asset protection features. And over the years, instead of getting weaker like most states, they actually have gotten stronger. Now, the other neat thing I love about it is, instead of relying on judges, they put it in the statute, and they did a belt and the suspenders approach. The Wyoming statute is one of my favorite statutes, just because they knew they were working with attorneys, and they doubled up on the clarification.
And who was that? What state was that?
That's Wyoming and Nevada.
Wyoming and Nevada. Okay. Should we name our trust as beneficiaries of our retirement accounts? And we've had a couple people ask that question. ERISA rate, IRAs, self-directed IRAs, solo 401ks, all that.
Great question. I love using this as an attorney. It depends. Now I'm gonna give you two scenarios here. If you have minor children, younger children, you don't want that designated beneficiary in the insurance policy or retirement policy to go right to your kids, because your kids will get the money right away at 18. In that case, we want to take a look at it and possibly have it go to the trust. Now, again, with retirement accounts and insurance policies, they have what we call a designated beneficiary. So it will go directly outside of probate. We really want to analyze that, and we don't want to screw that up. And so, it's going to depend on your family situation. It has to be looked on a one-on-one basis. But those are the two sides of it. If you have minor children, I really would suggest that go into the trust and then being distributed according to the rules of the trust. If not, it depends on maybe even a blended family. Maybe you wanted to use that insurance policy to go ahead and take care of your kids from previous marriages, things like that. So there's a lot of different ways we can look at it. One of the things you're going to get with this trust offer, you're going to get a one-on-one consult with the actual estate planning attorney, and they're going to describe every single section and go through the pros and cons of all of your answers. And so before the trust is finalized, you will have a one-on-one consultation with the estate planning attorney.
Got some of these questions I really want to address, but they're so particular to that situation. I don't think it's appropriate for everybody. Can a living trust continue to provide for me while I'm still living, or is the money off limits since it's in the trust?
Excellent question. And that's a rumor out there. While you're alive, you're the trustee and the beneficiary. So if you want to take money out of the trust, take an asset out of the trust, that's your right as the trustee and beneficiary. So no, it's not locked up. Now, this is again it's a rumor out there. And when I went over irrevocable versus revocable, if it was an irrevocable trust, the money would be locked up. But not with a revocable trust. You're able to access it.
Got it. Okay.
Freely, I should say.
Right. Yeah, I mean, and you addressed this briefly, but we've got a couple more questions on it. If I set up a living trust in state A and later move to state B or state C, do I have to redo the living trust or amend it?
Most likely, and it's more from a procedural aspect. What we want to do is make sure the documents are in place, they're recognized. The two of the most important documents that we want to make sure it's state specific are going to be your medical care power of attorney or financial power of attorney. Because if you go into the hospital with a medical care power of attorney that's drafted for another state, the person at the counter, they don't recognize it. Same thing with a financial institution. We want to make it, again, this is for the protection of you and your family. We want to make it as simple as possible so that you're not running into a problem with that. We want to make sure that, if people don't recognize certain things, the answer is no. And so we would want to redraft specific documents in there. And most likely, take a look at redrafting the trust according to the rules of that being state specific.
But yeah, I mean, some of us are fairly nomadic, so we don't want to have to redo the whole darn trust every time we move to a new state. But if it's just the HIPAA and the medical power of attorney that need to be looked at,
correct.
The rest of it can just remain as is.
Most likely, that's the way it's going to be because you're able to contract for the jurisdiction.
Okay. And you've kind of touched on this, but it sounds like, does your fee include setting up everything, including setting up LLCs, business advice, dynasty trust, and living trust, or is the $2,500 just for the living trust? And then, I mean, can you explain like the LLCs and the Platinum program and things like that briefly to give people kind of an idea? Because $2,500 sounds like is just one part of the story.
Yeah, no, it's just for the trust and the accompanying documents, the power of a will, the schedule of gifts, those documents that I went through. And then, it depends on what sort of situation you're in. One of the things that we did do, we got kind of in a situation where, clients got a little cheap because, if you're spending $2,500 per LLC or, $3,500, depends on the type of LLC you're going to look at. And then you have to keep paying that. We were finding clients were putting too many properties in one LLC to save a buck. And, we had a question one time, it was to Clint Coons. Hey, how do you structure it? You sometimes say, hey, group properties together. How do you do it? And he said, hey, I worked way too hard for my assets. I separate them out. And so what we did is we looked at the situation. We had an analyst come in and take a look at the cost structure. And what we came up with is what we call our Titanium program. Titanium is unlimited LLCs, basically all you can eat. The other thing that got in the way of some of our clients is they didn't want to call us if we were billing them by the hour. I think everyone who's worked with an attorney cringed calling. So what they would do is they'd phone a friend, look on the internet, get wrong advice, go down the wrong path. We'd have to act like janitors and clean up the mess. And so what we do also is offer a platinum program, which platinum basically is a big database of forms, contracts. The most important part is you're able to call in and speak to attorneys to go over your situation and answer questions, and you're not going to be billed by the hour. Hey, which, our attorney is basically $550 to $750 an hour. So it's $35 a month. The analyst said, hey, listen, you have enough clients that everyone can kind of pitch in, and it's the benefit to you and to the client. And what it did is remove that barrier to planning and barrier to getting your questions answered.
Yep. And how much is the platinum program? I think you said $35 a month.
Yeah, with it depends on when you're coming in. We like educated clients. So if you're just off the street, you never had any dealings with us, it's $2,500 initiation. Your advisor can go over that with you, but then it's $35 a month. And it depends on what you're doing. There are discounts with some of the services we provide.
Right. Okay. Gotcha. All right. A lot of these are just kind of repeats. If somebody's a single person, they have no heirs, do you still think it's worth it to set up a living trust?
Absolutely. I ran into that same situation. I put off having my living trust because I didn't have any heirs, and I thought it would be kind of funny to watch my brothers and sister fight over my assets. The only problem is if I left it, to them, one of them would go buy bigger wheels for his truck and blow it. I worked way too hard for that to happen. I also have a big charitable part of my life, and I want to make sure that the charities I choose, that's where the money is going. And so, again, with us as investors, we've sacrificed and worked too hard just for it to go through the probate and an attorney make money off of it. I wanted to designate what charities and how I wanted to distribute it out. It's absolutely single.
Okay. In the absence of an LLC and holding LLC, in other words, this person doesn't have either one of those things, can I still use a trust?
Absolutely. What you're going to be doing is just titling that property in the name of the trust,
right.
So that it goes into that suitcase. You're carrying that suitcase around. Now, here's the problem. If it's a rental property and you get sued, you don't have a structure in place, you are liable for any action that happens on that property. You've got to get an LLC. It's not even an option anymore. It's cost benefit analysis. I cringe. I'm a recovering plaintiff's attorney. I understand what people, especially right now, we are in a situation where people are going to be hurting for money, and the way that they're going to get it is sue. And every single landlord out there, you're looked at as having deep pockets, and you're the people they want to take it from.
Yeah. Oh boy. Okay. You got a lot of questions on this $800 fee. I know it's kind of a little bit beyond the scope of a living trust thing, but
I love dispelling information and providing clarity. I feel like every investor, we're all in the same boat. We all need to help each other out.
Okay, couple more things. If a property is in another state and the LLC is in Wyoming and they live in California, but the rental property is not in California and the holding property is in Wyoming, do we still have to pay the $800 fee to California?
Franchise Tax Board says yes, there are some workarounds, but what I would do is just go ahead and pay it. Yeah, I mean, us that lived in California, live in California, we understand that these are just costs of doing business.
Mm-hmm. All right.
There are workarounds I would get with an advisor. We can take a look at it.
Yeah.
But there's a value to keeping things straightforward.
Yeah, but there's also a value to workarounds, depending on your perspective. All right. Why is it
some of the workarounds on a webinar? We play telephone, and pretty soon it'd be like, all right, let's file a LLC on Mars.
Right. Taxman can't get us there.
That's right. But I think California actually would claim they could.
Yeah, they probably could. They probably have an emissary there waiting behind some red rock to spring out from behind it and collect their tax bill.
Yeah, the franchise tax board already set up an office up there.
Yeah. Why is an LLC more important than high umbrella insurance?
Oh,
Because
great question. This is
we
one
get that question a lot of times, like, okay, I could go around and set up all these LLCs, but why don't I just get an umbrella, $3 million umbrella policy over all my properties?
Oh my gosh, I get this all the question all the time. And generally, what happens is a client will go to their insurance provider or their accountant. The accountant says, just get more insurance. I encourage everyone to go ahead and read their policies and get to the end of it. I know that's going to be tough, but if you get to the end of it, you're going to find all the exclusions. The other problem we have is judgments are above and beyond insurance limits. Couple that with the exclusions. Bad advice, horrible advice. In fact, if you ever get that advice, have that insurance agent or that accountant guarantee if the insurance policy doesn't cover it or it's above and beyond insurance limits, that that advisor will go ahead and pay that deficiency. I've been recommending this for over a decade, and not one of those advisors have ever gone ahead and said, okay, that was advice, I'm going to go ahead and sign that contract. It's one of my biggest pet peeves. It's an ignorant statement. I'm sorry I'm getting worked up on it. I just feel so many people have fallen in that trap of relying on insurance, which we all know insurance companies are not in the business of paying off. What they want to do is just rubber stamp the denial and see if you come back. There's way too many exclusions.
Okay.
Again, I've seen too many people hurt with this. I do not want you guys to be hurt.
Gotcha. Okay, so you can still have an umbrella, but don't rely on that umbrella to save you in the event of an.
Absolutely have an umbrella. I mean, they're cheap, and there's a reason why they're cheap. They're ancillary insurance. I've got an umbrella. It's cheap. I think why not throw a $300 to $500 a year and get it done. Maybe I'll pick it up, but I'm not going to rest my portfolio. Guys, again, I came from nothing and I sacrificed way too much. I mean, this isn't something to play around with, especially when I really believe that we already live in a litigious society. You guys are the ones that everyone's looking at to go ahead and get money from. To just rely on a company like an insurance company to pay out when you know they're not in the business of doing it, I think it's just really, really poor.
Yep. Okay, well, we need to wrap this thing up. I'm going to take this one last question here. Can an investor themselves look up to verify if the ownership has been recorded in a trust in the county state records?
The way that we set up, this is a very important question. It's a system that we put together, right? The way that we set it up, we can keep your name out of public record. Okay, you may be in chain of title, but you're not the current owner. And so chain of title doesn't matter. But the biggest thing is we love privacy. It's nobody's business on what you own. And so what we would do is we would set it up using kind of the system with the holding LLC. One thing about Nevada and Wyoming is you don't list the actual owners of the LLC nor the players. And so there's privacy. And then we can take that and extrapolate that by designing it in a way that the ownership is held by that holding LLC. Keep your name out of public record. And as a plaintiff attorney, one thing I used to do is I'd qualify you for a lawsuit. I'd find everything that you owned, and then I'd go after it. If I can't find it, I don't think you own anything, I'm going to settle, or I might not even take the case. As a plaintiff's attorney, you cannot take cases in which you cannot get paid out. You've never heard of a homeless person being sued, period.
Yep.
Yeah.
Sad but true, or just true. All right.
And I have a feeling it's just going to get worse. We saw it in 2008, 9, 10, 11, 12. People were desperate.
Yeah. So is this the last slide, or is there a kind of a goodbye?
No. On behalf of Anderson and myself, I really wish you guys the best of success in your investing in your lives. Stay safe, and I hope you guys got something out of it. I hope you saw the passion behind it. The passion comes from the experiences that Anderson and myself and other attorneys have gone through with clients. Please put this on the forefront. Don't keep putting it on Someday Island, and just have a ton of respect for you guys as investors and business owners.
Okay, well, Michael, good job. Thank you so much. And just once again, sign up at andersonadvisors.com/Fettke, F-E-T-T-K-E, after our fearless leaders, Rich and Kathy Fettke.
Which I love them. They're such great people.
Yep. And you'll get $1,000 off, $2,500, and you're able to can they sign up? And you may have touched on this, and I just forgot, so I apologize. But by signing up for a strategy session, are they committing at that point to the 2530 for the 2500, or is that like a free consultation type thing?
I think I'll make sure that you can do both.
Okay.
And I just want, again, it sounds like there's a lot of people out there that have bad information. I'd rather have you sit down with one of my advisors and get the couple of books. If it's, originally I wanted to include all these bonuses, but after the webinar, let me try to get it opened up to that.
Okay. Well, I didn't mean to put you on the spot. I just wasn't sure about that.
Right thing to do.
Okay. Okay, perfect. All righty. Well, Michael, thank you very much. And thanks to all of you. I'm sorry for going over, but we had a lot of good questions. We wanted to stick with it. This will be archived on realwealthnetwork.com in the investor portal. So you'll be able to watch it again if you missed the beginning or end. I had to go. Once again, my name is Ben Smith. I'm the Director of Investor Relations for Real Wealth Network, and he is Michael Bowman with Anderson Advisors. And I guess that's it. Thanks a lot, Michael.
All right, guys. Best of success. Stay safe.
Bye-bye.